The Supreme Court just shattered decades of federal enforcement power with a single emergency order that's sending shockwaves through every government agency in America. 8 justices against 1 decided something so significant that federal agents are scrambling to figure out how they'll do their jobs tomorrow morning. This isn't about politics anymore. When justices who usually can't agree on anything suddenly unite in an 8-to-1 decision, something fundamental just shifted in how power works in this country. The lone dissenting voice actually revealed the exact blueprint states needed to make their laws bulletproof, and they're already rewriting legislation as we speak. Federal agencies relied on a system of cooperation that just got completely dismantled. For decades, they've used state databases, local police backup, county jails, and state crime labs to enforce federal laws. That entire framework just became optional, and states are racing to opt out. The emergency order came with almost no warning. Legal experts expected months of deliberation, but the court moved with unprecedented speed. The 8-to-1 split tells us this wasn't a close call or a partisan divide. This was a constitutional principle so clear that ideological opposites found themselves on the same side. What triggered this emergency order was a clash between state preservation laws and federal enforcement authority. States had been passing laws saying their resources couldn't be used to enforce federal regulations they deemed unconstitutional. The federal government challenged these laws, expecting the usual lengthy court battle. Instead, they got an immediate answer that changes everything. The court didn't just rule on one specific law, they created a comprehensive framework that every state must now follow. This 3-part test determines which preservation acts survive and which ones die in court. Understanding this test reveals why some states are celebrating while others are frantically rewriting their laws. First, states must clearly define which specific federal actions they consider unconstitutional. Vague statements about entire categories of federal law won't survive anymore. The law needs surgical precision, not broad brushstrokes. Second, states can refuse assistance and cooperation, but they cannot actively obstruct federal agents using their own resources. There's a line between non-cooperation and interference, and crossing it means losing in court. Third, the law must include severability clauses allowing constitutional portions to remain even if other parts get struck down. This prevents entire laws from collapsing due to one problematic provision. These requirements mean roughly half the preservation acts nationwide need immediate revision. States like Missouri, Montana, and Arizona drafted laws with sweeping language that's now vulnerable. They're racing to fix these vulnerabilities before challenges arrive. The practical impact hits federal agencies hardest. The ATF has approximately 2,600 agents covering all 50 states. They previously coordinated with over 800,000 state and local officers. That force multiplier just disappeared in states choosing non-cooperation. A typical federal investigation used to involve quick calls for state police surveillance assistance, county jail facilities for holding suspects, and state ballistics databases for tracing weapons. Now federal agents must handle everything themselves, turning one-day operations into week-long resource drains. Some enforcement priorities are becoming impossible in non-cooperative states.
The weapons unto themselves, they're not the problem. The problem is, what are you doing with the weapons?
You need to be on the right side of the law because the legal system is complex.
This is a case dealing with a state's Second Amendment Preservation Act, also known as the SAPA law.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
Officers face greater scrutiny. Courts can weigh how their actions contribute to the need for force. Citizens gain stronger Fourth Amendment protection.
Federal officials privately admit certain investigations simply won't happen anymore due to resource constraints. The infrastructure they depended on for decades vanished overnight. Federal detention facilities only exist in 37 states. In the other 13, arrested individuals must be transported hundreds of miles to the nearest federal facility. This creates massive liability issues, pulls agents from other duties, and causes delays that can destroy time-sensitive cases. State forensics labs that processed evidence in 2 to 3 weeks are now off limits. Federal labs facing 8 to 12-month backlogs must handle everything. Prosecutors are declining cases they would have pursued before because the resource investment makes prosecution impractical. The ATF already closed 2 regional offices in Preservation Act states. The offices couldn't function effectively without state cooperation and weren't producing enough cases to justify overhead costs. Environmental Protection Agency enforcement in non-cooperative states dropped 65% according to leaked internal data. But federal agencies aren't surrendering. They're developing workarounds that might make enforcement more aggressive in some ways. The adaptation strategies reveal how determined federal authorities are to maintain their presence everywhere. The ATF is hiring retired state and local officers as contractors, buying the local knowledge and relationships that current state employees can't officially provide. It's an expensive workaround, but it keeps federal operations functioning.
There are some states and commonwealths we're talking about where this will be a felony.
All right, we've got this breaking news just coming into our newsroom right now.
Is a massive deal. It directly goes after the ATF's tactics over the last 2 years.
These injunctions have allowed district court judges to be emperors, and they cannot do that.
Basically, they kick the ATF in the teeth. They seem kind of punch drunk. They seem as though they got the bell rung pretty bad.
ATF is getting another lawsuit, this time by half of the country.
The FBI is expanding its task force model beyond terrorism to include gun enforcement. They're creating financial incentives for individual state officers to work under federal supervision rather than state command. It's a way to get cooperation without going through state channels. Administrative subpoenas and civil enforcement actions are replacing criminal prosecutions. These tools don't require search warrants or arrest operations where state assistance would be needed. The shift from criminal to civil enforcement changes how federal power gets exercised. The Justice Department is suing states directly rather than prosecuting individuals. Constitutional litigation becomes their primary tool when criminal enforcement isn't practical. It's a complete reversal of traditional enforcement priorities. Private data vendors are replacing state databases. Federal agencies purchase information from companies that aggregate public records and commercial sources. It costs more and might be less reliable, but it's available without state cooperation. Informant payments in non-cooperative states have increased dramatically.
Constitutional protections of your home are absolute.
First of all, it's important that you know the gun and concealed carry laws in your home state and anywhere you plan to carry.
The civil remedy here, or the lawsuits here that are going to be filed, are not going to be filed by the state of Missouri.
And I think it's pretty simple, is that we want to do our due diligence if we're looking to give people gun rights.
Even if you are innocent, your words can still be twisted and taken out of context.
The DEA compensates for lost official intelligence sharing by paying street-level sources more money. The cost of enforcement keeps climbing while effectiveness potentially decreases. These workarounds create a two-tier system where federal enforcement looks completely different based on geography. Citizens in cooperative states face vigorous federal enforcement while those in non-cooperative states experience minimal federal presence. This disparity raises serious constitutional questions. The Equal Protection Clause supposedly guarantees uniform application of federal law. But this new reality makes geographic enforcement disparities inevitable. How can federal law be supreme if it's barely enforced in some states due to resource limitations? Some scholars argue states are exercising a form of nullification the Supreme Court rejected after the Civil War. The counter-argument distinguishes between declaring federal law void and simply declining to enforce it. But that distinction blurs when non-enforcement makes the law effectively meaningless within state borders.
Our citizens want gun safety, want firearm safety, want community safety.
Open carry has historically been regulated. The U.S. Supreme Court has said those types of regulations would be improper.
The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act for the purpose of making a state a two-way sanctuary state.
With gun control being implemented in a number of states, even where least expected, this is not a bill that gun owners should ignore.
The Supreme Court recently denied a stay that would have protected a state's Second Amendment sanctuary law.
Congress might try conditioning federal funding on state cooperation, essentially buying what they can't commandeer. States accepting federal money might have to accept enforcement cooperation requirements. This could trigger another round of constitutional battles. International treaty obligations complicate matters further. The United States has enforcement commitments under various treaties. State non-cooperation could put the country in breach of international agreements, creating diplomatic problems beyond domestic law enforcement. Justice Sotomayor's lone dissent actually helps states more than it hurts them. She agreed states have anti-commandeering protections, but argued certain provisions crossed into active obstruction. Her specific objections became a roadmap for bulletproof legislation. She focused on penalties for state officials who voluntarily cooperated with federal agents, Punishing employees for choosing federal cooperation crossed the line from non-cooperation to obstruction. States can refuse to mandate cooperation but can't punish voluntary assistance. The dissent also criticized provisions allowing citizens to sue state officers for any federal cooperation. This created a chilling effect beyond simple non-cooperation. But even in dissent, she acknowledged states have broad authority to decline participation in federal schemes. Within 48 hours, 7 states began circulating revised Preservation Act language, addressing every concern from the dissent. The speed of revision was unprecedented. Usually, states take months or years to respond to Supreme Court guidance. Here, comprehensive rewrites happened in days. The new model legislation removes penalties for voluntary cooperation while prohibiting official state support. Officers remain free to assist federal agents in personal capacities without using state resources. It's a surgical approach that maintains protection while avoiding constitutional problems.
There's a myriad of things that can tie you up legally, financially, put you in jail, or maybe get you in very serious trouble with the police.
It said in part that gun regulations must be consistent with the historical tradition of firearms regulations in the U.S.
So the Supreme Court has issued an order in the critical Second Amendment Preservation Act's challenge that was pending in front of their court.
If you're going to restrict a constitutional right, it has to be consistent with the nation's historical traditions of firearm regulation.
A lot of what we hear this morning is trying to figure out what is our nation's history and tradition.
State said we are going to take away all the funding that we are giving federal agencies when they come into our state and are trying to violate the rights of residents.
Montana introduced a revised bill within 72 hours that Legislative Council believes eliminates every objection while maintaining protective effects. Oklahoma's Attorney General declared their existing law already compliant and needing no changes. Blue states are studying these frameworks for protecting marijuana legalization and sanctuary city policies. The anti-commandeering principle applies beyond guns to immigration, drugs, and environmental issues. If states can refuse cooperation on Second Amendment grounds, the same logic extends elsewhere. Arizona already introduced legislation applying non-cooperation to immigration enforcement. California considers similar approaches for environmental regulations exceeding their own standards. The principle established for guns is spreading to every area of federal-state tension. This ruling's timing couldn't be more significant. Multiple states are expanding what they consider unconstitutional federal overreach. The list of targeted policies grows daily, going far beyond firearms to include healthcare mandates, educational requirements, and energy regulations. The constitutional consensus achieved in this 8-to-1 decision provides cover for states across the political spectrum. Liberal states can use conservative legal victories to protect progressive policies. Conservative states can use precedents from sanctuary city cases to shield gun rights. Federal agencies face a crisis beyond needing more agents or bigger budgets. They're confronting fundamental operational limitations money can't solve. The cooperative framework they've relied on since their creation just ended in large portions of the country. Some federal prosecutors indicate they're becoming more selective about which cases to pursue. Resource constraints force prioritization in ways that didn't exist when state cooperation was available. Entire categories of federal crimes might go unprosecuted in non-cooperative states. The long-term implications stretch beyond current political alignments. States celebrating today might fight this principle tomorrow when political control flips. The power to refuse cooperation works regardless of which party controls federal or state governments. Future Congresses might try creative solutions to restore enforcement capabilities, but the constitutional principle established here limits their options significantly. The anti-commandeering doctrine has deep roots the court just reinforced dramatically. This emergency order represents just the beginning of a larger constitutional transformation.
First and foremost, basic gun safety does not have to be a threat to the Second Amendment.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
That seems like guilty until proven innocent. That's not within the lawful jurisdiction of a government.
It is unconstitutional.
The public is demanding of its public officials that we take action.
This shift could influence all circuit courts.
The relationship between federal and state power is being fundamentally renegotiated through these preservation acts and court decisions. How this plays out will directly impact every American's daily life, determining which laws get enforced where and how vigorously. The geographic inconsistency in federal law enforcement challenges basic assumptions about American governance. We might be entering an era where your zip code determines your relationship with federal authority more than any time since before the Civil War. That's it for today, folks. See you in the next video.